So exempt assets that would be exempt from equitable distribution, again, is a very relative term because technically you have to make a showing. It's on your burden. You have that burden of proof to go ahead and prove why a specific asset would be out of what we call the marital pot. Now that could be because you've had this asset for 10, 15 years before you got divorced. It could have been that it was 2 years before you got married per se. It could be 2 years before you got married. Basically, nothing is out of the question when we're talking about what's subject to the divorce. It's really what the parties again will agree to. However, normally there are circumstances where a party had a car well before they got married. That car would pretty much be a exempt asset, except for the fact that we do have what's called transmutation. And that is a concept where you can take a premarital asset and turn it into a marital asset by way of allowing your spouse to use the car. If it's a vacation property, you're going to allow your spouse, you spent every summer there, or things like that. There's also the concept of commingling. Let's say you had a premarital bank account. If you never touched it during the marriage and it was all funded prior to the marriage, you would have a very good claim of that being exempt. However, if you started taking your earnings, and even though they're your earnings, they're still marital dollars that you're putting into that account, taking out, putting into the account, again, it's commingling, and it could commingle that account to put that account back into the marital pot.